successful subrogation program, and so the eye must always be on the bottom line. It's something that we have to deal with that a lot of defense liability folks don't have to deal with. Their budget is run by the demand in the complaint. Ours is run by the fact that we have to be effective and efficient, and we have to take into consideration the amount we're looking to recover in every case. That's why this subject of forensic experts in subrogation cases is so important. When do we use them? How do we use them? Why do we use them? And do we use them at all in smaller cases? These are some interesting subjects that don't get a whole lot of attention, but the cost of experts and the effect that they can have on even a mediocre subrogation case remains one of the most interesting and expensive aspects of litigation. So the use of expert witnesses has become integral and almost indispensable to American litigation these days. There's been a sea change over the last 20 years in terms of what the jury is going to hear and what they believe and when an expert is needed. And it is often the side with the best expert who wins the day. The same holds true for subrogation files, in which you, the subrogated carrier, or your client must invest in an expert, and that's real cash out the door to assist in meeting our burden of proof, because we're plaintiffs in subrogation cases, as we all know. And experts can be expensive, so it's important and it's best to pick and choose an expert who will be able to withstand judicial scrutiny. He or she won't be challenged. We've really saved very little, or your client has saved very little, if we pay fees to an expert who is later barred from testifying. Or if we pay money to an expert who later doesn't really provide us the information we need, or hasn't come up with the opinion that's necessary to get us across the goal line. So knowing a good expert from a bad expert goes a long way in holding down the bottom line and squeezing as much as possible out of each subrogation file. So with that, let's get started. I want to start with an illustration. I frequently recommend not using an expert in a case. It always depends on the amount involved, how much money is involved, the nature of the case, how easy it is to prove liability. But the power of an expert can't and shouldn't be overlooked. Let's start with 10 fun facts. And this is an illustration of why experts can be powerful. All right, I'm talking to you. You are in various locations across the country, and I'm going to relate to you 10 fun facts. Fact number 1, you can't see your ears without a mirror. Fact 2, you cannot count your hair. You can't breathe through your nose with your tongue out. You just tried breathing through your nose with your tongue out. When you tried it, you realized it is possible, but you look like a dog. You're smiling right now because you breathed like a dog. We skipped number 5. You just checked to see if there was a number 5. You are doing all of this because I, at present, am in a position of authority. I am the supposed expert. I'm controlling the PowerPoint. I have information you want, or hopefully have information you want about using experts in subrogation cases. This is exactly why experts can be so powerful in a case. The power of an expert is based upon the juror's perception that someone accepted as an expert by the court has a high level of knowledge or specialized set of skills that ordinary people do not possess. They can hijack the juror's mind. Read that last sentence again. They can hijack the juror's mind. This is what you want to do. This is how lawyers win cases. Experts don't win cases, but they can help the lawyer win the case. So experts can be powerful. And this illustrates that, because we're sitting here going through an expert webinar, and you just tried to, or at least imagine, breathing through your nose with your tongue out. This is what an expert can do in the right case. So, what color is this house? This is what we talked about, hijacking the juror's mind. When confronted with a question, even the simplest question, it momentarily hijacks our our thoughts, our thought process, as we focus entirely on the answer. What color is this house? We don't consciously tell our brain to think about that. It just does so automatically. So questions, the simple act of asking a question, are very powerful. When a question is asked by an expert, either in deposition or a trial in front of a juror, we hijack the juror's mind, just like I hijacked yours on the previous screen when you stuck your tongue out. They are no longer thinking about why the LA Rams or the Kansas City Chiefs are having such a good year, or why the Astros and the Brewers are not in the World Series. But they're thinking about the question and the answer to the question, what color is this house? Not only does hearing a question affect what a juror's brain does in that instant, it can also shape how they answer the jury questions at the conclusion of the trial. And that is the money question. It's the ultimate questions that they sit there and fill out, yes, no, 100%, $79,000 and $84.12. I mean, that is what all of this is about, is getting the jurors to put that number in that box, or hopefully settling before that happens, because the other side is afraid they will put that number in that box. Harnessing the power of the expert is, in the right case, can mean the difference between settling and not settling, between settling a good case and settling a bad case, between winning and not winning. They add value, but they must still be used efficiently and cost effectively. And that is one of the most important things that we have to be concerned about. Not to belabor or get too hyperbolic on some of this, but the brief history of expert witnesses in court is useful, because it's important to understand that we weren't always here. In the 1920s, there were no experts in civil litigation to speak of. Eventually, around the end of the 1920s, psychologists were called in to testify in a few discriminated cases involving Coca-Cola. There was a case called Coca-Cola versus the Chero-Cola Company, in which Coke sued Chero-Cola for patent infringement and trademark infringement, and psychologists gave expert testimony in that case as to whether Chero-Cola's trademark would cause confusion because it was too similar to Coca-Cola's trademark. Advance a few years, in 1932, and we came across the case of Fry versus United States. We'll talk about this in a little while. This changed both criminal and civil trial forever by addressing not only an issue in criminal cases, the use of polygraph tests, but also the use of expert witness testimony. And then we fast forward to 1975, and Congress issued the Federal Rules of Evidence. Rule 702 provided a standard for expert witness testimony that answered some of the tougher questions relating to Fry and when experts can testify. In 1993, the Supreme Court granted cert and made a ruling in the Daubert versus Merrill Dow Pharmaceuticals case. We'll talk about Daubert, but you probably have heard that name, and you know that this is the case that addresses the expert standard. Should expert evidence and testimony be allowed? If it's generally accepted, should it meet some other set of requirements? And the court in that case, as we'll see, provided 4 guidelines. Number 1, is the expert's theory or technique tested? Is the theory or technique accepted? Does it have an acceptable known or potential rate of error? The existence and maintenance of standards controlling the technique's operation, and then whether the theory or technique is reached the level of general acceptance. So Daubert became the federal standard for expert witness testimony. We will make references to our website. The Matthiesen, Wickert, and Lehrer website has, as many of you know, a number of resources that are of use to subrogation professionals. This includes charts on just about anything and everything you could think of. Charts on workers' compensation, documenting workers' compensation future credits, employee leasing laws, made whole doctrine, statutes of limitation, and landlord-tenant subrogation. It includes a chart on expert admissibility. So when you're looking at hiring an expert, it's important to go to that chart and just ascertain exactly what is the requirement in order to meet that burden of proof. So after Daubert, the one question which Daubert didn't answer was which expert witnesses had to be evaluated according to the case's standard. Did Daubert apply only to science and technical witnesses and subjects? But in 1999, the U.S. Supreme Court issued the decision in Kumho Tire Company versus Carmichael, and they answered that question by holding that Daubert's standard applies to any expert witness in federal court, whether their testimony was scientific, technical, or otherwise. So this is the court's gatekeeping function, and that's in a nutshell the brief history of expert witnesses. Now, again, that chart, because this addresses federal cases, that chart that I was referencing actually deals with what the state law says in each particular state. Does the state rely on the Frye standard, on the Daubert standard, or does it rely on some other standard for admissibility of expert witnesses? That's something that is important for us to know, even as subrogation professionals, which, as I've often said, is more than just sending out demand letters. You guys are litigators. You guys are trial lawyers. You're plaintiff's lawyers. You put on that plaintiff's lawyer's hat when you think about these things. So, why do we need expert witnesses? There's pros and cons. The role of the forensic expert is to help a jury understand. And it helps them understand technical issues. It helps the plaintiff or defendant prove their case. Because once one side gets an expert, it's a lot like the joke about a lawyer in a small town. He's starving, can't make a living until a second lawyer moves into town, and then all of a sudden his business is thriving. It's the same in litigation. You don't want to hire an expert unnecessarily. A simple rear-ender probably doesn't require an expert unless there's some allegation of brake failure or visibility or some other technical issue that has to be addressed. So the pros are they help the jury understand, they help us prove our case. The cons, they prevent the plaintiff from representing themselves. The need of an expert makes a case much more complicated and really requires lawyers to get involved, and it requires an investment which a lot of individuals aren't willing to expend themselves. It also makes subrogation a little more expensive. But in the right case, we just have to remember the underlying theme that subrogation is an investment. It deters plaintiff's lawyers from taking smaller cases. Why is that important to us as subrogation professionals? Well, because if you have a case with $7,000 in medical expenses, no lost time, work comp, subrogation case, and the plaintiff is gone to an attorney, that attorney's going to look at the case and say, wow, do I really need to prove there was a defective General Motors vehicle here? If so, I'm going to spend 3 times as much money on experts as I would in the amount of money I'm hoping to recover, and it would deter him from taking the case. I'm a fan of the Lord of the Rings trilogy, and there's an exchange that occurs in Book 1, Chapter 2, if you enjoy books more than the movies. And this really drives home to me where we are in terms of history with regard to experts and cases. If you recall, in that scene, Gandalf explains the history of the ring to Frodo, and the it to which Frodo refers is the finding of the ring by Gollum. And he says, I wish it need not have happened in my time, said Frodo. So do I, said Gandalf. And so do all who live to see such times, but that is not for them to decide. All we have to decide is what to do with the time that is given to us. This is where we are in history. As subrogation professionals, we're at a point where jurors expect to be taught. They expect to be spoon-fed the science and the technology necessary for them to come to a decision. Do you find from a preponderance of the evidence that the 1990 Buick LeSabre was defective in design? Well, they have no idea. They need an expert to tell them that it was defective. And then the defense is going to want to have an expert who says, no, it wasn't defective, or it was defective, but it was state of the art at the time, or whatever their defense is. So forensic expert testimony has become a necessity in many types of litigation, and therefore, despite wishing it weren't so, To successfully subrogate, we must embrace this fact, work to build an arsenal of qualified, cost-effective experts who will serve our needs, and pray for the wisdom to know the difference between the case in which we need an expert and the case in which we do not. One of the resources that we have available for our clients and friends is a database of experts that we have been accumulating since 1985. It's an expert database of some 30,000 names of experts in every discipline you can imagine, broken down by geography, area of discipline, and cost. We also, where possible, make notes on how well these experts do at what they have to do best, and that is testify live in front of court. Some of the smartest guys in the world make horrible experts because they cannot relate and communicate to a jury. So modern day has seen the advance of science in almost every discipline, and this has resulted in complex subjects and principles being explained with greater clarity and certainty. DNA evidence, ballistics, forensic evidence, metallurgy, these have all required the courts now that we have this knowledge to decide legal issues based on complex facts. And that is just something that, as Gandalf said, that's the time that is given to us. So different types of experts. This is all a little bit of a background till we get the more practical aspects of which experts you want to hire, why you want to hire them, where do you want to hire them, how much do you want to pay them, and once you pay them, what are you going to have them do? There are two types of witnesses in most civil litigation: percipient witnesses versus expert witnesses. Percipient witnesses are those who perceive something. I saw something happen. I witnessed the car running the red light. I heard Joe Bob say X. They have perceived something. They're percipient witnesses. They are lay witnesses, and they're going to testify to something as a lay witness. Facts. I saw this. Opinion testimony by lay witnesses is restricted to opinions that are rationally based on the perception of the witness. The boundaries of that depend. I saw something. It was hot. Well, that's his opinion. What's hot? Well, to him, it was hot. The car was traveling at a high rate of speed. How high? I believe around 70 miles an hour. Some courts allow that because we are all, quote unquote, experts in driving. We've all driven, and we have a good perception based on experience as to speed. But for the most part, opinions are left to expert witnesses. These are qualified engineers, scientists, people of advanced learning, some people from academia. They're usually hired by attorneys to study some sort of a problem, provide a professional opinion as to a technical aspect in a case. There's different types of expert witnesses. There are the independent expert witness, usually treating doctors. They're not paid by any party to testify, but they have special knowledge. So they're out there doing their job, but they have knowledge that we need in order to decide a medical issue in a case. There are controlled expert witnesses. These are the expert witnesses we normally think of when we hear the term forensic expert. They are what you think of when you think of an expert witness. Think of a mechanical engineer in a leaky dishwasher case. Let's see, a metallurgist in a case involving a failed piece of a product, or a hammer that broke, or a piece of metal that broke off, or how about a traffic accident reconstructionist in an auto crash. In many personal injury and medical malpractice cases, these are a lot of the experts that we use. We use doctors hired in medical malpractice cases to provide a specific set of opinions that the treating doctor either cannot or will not provide. Did Dr. X commit malpractice? A lot of doctors don't want to do that, so we have to go out and hire one who will. There are consulting versus testifying experts. Consulting experts do not have to be designated, and they play an important role. They help you understand if you have a case. They're generally cheaper, and we don't have to be as picky in hiring them unless you might ultimately want to have them testify. But generally, you can obtain a consultant for their advice and guidance. You can keep them secret. They're not deposed by the opposing party. They provide you with advice and hopefully give you an advantage in understanding the issues in the case. Then the testifying expert, of course, is what it says it is. It's an expert that gives an expert opinion, presumably bound for the testimony at trial in front of a jury. They can be subpoenaed for deposition. They have to provide reports, provide their claim files, their expert files, and so forth. And while they perform most of the functions of a consultant, their level of confidentiality, and we'll talk about this later, is tempered a little bit by the fact that they have to be compelled, they can be compelled to produce things that you might not want produced. And that's why we have to be careful with them. A rebuttal expert is essentially an expert used to contradict the opinions of another expert and say that that expert is all wet. And then there's, I refer to them as hired guns. These are the experts that we can all go out and get. They do a lot of advertising. They're expensive. They are experts in everything. And generally they are frowned upon by the courts. The defendants know that they're hired guns and that all you got to do is cut them a check and they're going to give you any opinion you want. We'll talk a little bit later on how to blind, quote unquote, blind an expert and avoid hired guns and get the right expert for your case. And lastly, I call them shade tree mechanics. These are guys with the name Bob on the front of their shirt, who with dirty fingernails, who are installing starters, fixing transmissions. And when it comes to an auto mechanic issue, sometimes they have more credibility than the PhD from Harvard. And they can be very, very effective because people relate to them. And guess what? They're cheap. So these are some different types of experts. And then the question becomes, which is the right expert? How do you know which expert is right? Hiring the wrong expert is worse than no expert at all. We give a webinar, actually a seminar, and I gave it just recently down in Houston last week, called the 10 subrogation mistakes that insurance companies keep making. Number 6 on that list is hiring the wrong expert, because subrogation has to be cost effective. We are always cost minded. We are always trying to, and this is mistake number 2. Sometimes we delay referring subrogation cases to subrogation counsel until it is too late or until the value of the subrogation claim has been detrimentally affected, because we're trying to save from paying attorney's fees. We're trying to save and avoid paying expert fees. This is natural. If you can write a letter and settle a case, great. But oftentimes we settle the case that requires an expert too cheaply. If we had just invested in an expert, it would have increased the value of the case, and we would have exponentially increased the net recovery, even considering the expert's fees. So some things to look for. An expert doesn't have to be a specialist in a particular area, but he or she must be qualified. An expert does not have to be licensed, but there are risks to having an expert who is not licensed in their area of expertise if it is subject to licensing. Licensing gives credibility. If the defense expert is licensed and yours isn't, you better believe defense counsel is going to be hammering that home to the jury, and someone on that jury, maybe somebody who went out and sweated and failed his or her real estate license exam twice, is going to put a lot more weight and credibility on the license that may not even be there than you even know, and you'll never know it. You'll just get a no vote from that particular juror. So some states require forensic experts, such as engineers, to be licensed. Others do not. An engineer should, but does not always need to be licensed in the state testifying in. That's a common question. Let's see, Dr. Williamson, I understand that you're testifying here in state court in Oklahoma and you're licensed in Texas. You're not licensed in Oklahoma, are you? No, sir, I'm not. Well, they're going to make a big deal about that. It's not required, but just to make sure that you match tit for tat the expert on the other side. You have to know the state's laws which allow a judge to strike an expert if he's not licensed. Alabama Supreme Court has a case in which the judge struck an expert because he wasn't licensed. And there's a statute in that state that you need to know about. Again, go to our chart on experts and you'll get immediately a synopsis of the law in that particular state. 3 myths about hiring experts, I think, and I get these from the Experts Institute's list. It's a great reference. It's a great website. Number 1, hiring an expert will help you win the case. The expert alone will not win the case. I think we too often rely on that. And as subrogation professionals, we rely on that. We get an expert. We go out and hire an expert, and then we send that expert's report, often written well before it should have been, and we send it on at an early stage in a claim because we're hoping the other side will see it and go, oh my goodness, this claims adjuster went out and paid $1,800 for an expert, and we better settle this for 100% right away. Doesn't happen. Usually does not happen. It's the lawyer's job to win the case, and the expert is there to help the jury understand the lawyer's arguments. I know that sounds like full employment mantra from a lawyer who's giving this seminar, but it is the truth, and the expert alone will not win the case, and you will see later on, and we have a number of expert witnesses, and I see some here on the list that I've used in the past and who are very, very good. And they're listening to this, and they know the fact that the more an expert thinks that he or she is going to win this case for his or her client, the less effective they will be. We'll talk more about that when we talk about what to have your expert do and what to not have him or her do. Second myth, the more experts, the better. Too many experts may intimidate the other side, but it's rarely effective because it's, number 1, expensive, and we're talking subrogation, so we have to be cost effective. And number 2, it increases the chances that your own experts will disagree with one another. That's a great cross-examination by defense. Well, Mr. Smith, Mr. Jones, who's also an expert for your client, said this. Well, I disagree with that. Well, you guys can't seem to agree on anything. It's hard to explain, but the more experts, the better is a myth. It's not actually true. Having one good qualified expert, sometimes you need 2 if there's a different discipline involved. For example, in fire cases, we'll talk more about this later, you need an origin expert, someone who's going to point to where the fire started but has no earthly idea of why it started. Then you're going to want the cause expert. This is a mechanical, electrical, chemical engineer who comes in and says, yes, this is where the fire started and here's why it started. And so you have 2 experts who fill the entire spectrum of what it is you need to prove. Third myth, the more expensive experts are better. This is not always true. It can be true. And in difficult cases involving warnings, especially warnings of automobile manufacturers or complex pieces of industrial equipment, sometimes the more expensive warning experts and the good ones are not as prevalent as I wish they would be. Again, supply and demand, that's why they're more expensive. But the cost of an expert is dictated by his or her demand. If an expert is good, and I've got some good ones I can recommend for the right case, the more money they can command. And being that we're a capitalist society, a free enterprise, it's supply and demand. But the demand is worth it. In the right case, it's worth it. So we're talking electrical, mechanical, and chemical engineers for the most part, but experts have to be able to teach. This is something that even a lot of experts I've used don't understand. They believe they're there to answer questions that are asked of them, and while that's technically true, those questions are just softballs that allow them to put on their teacher's smock, stand up in front of the jury, and translate complex scientific issues for lay people. Somebody who bags groceries at the local Piggly Wiggly, to translate complex scientific issues for someone who hasn't been in school for 60 years or someone who never took any science classes is not an easy thing to do. And to do it without putting the jury to sleep is important. So if an expert rather doesn't explain the scientific issues to you, once you hire them, if they don't explain it to you in a way that makes you go, oh, I see, don't use them. A good teacher must be able to put himself in the place of those who find learning hard. And I always said, you have to be able to teach somebody something as though they were a first grader. If you can't explain something in a way that a first grader can understand, you're not explaining it well enough or in a succinct way. This isn't always possible, but it should be the goal. They have to be confident without being condescending. You can go on YouTube and just Google or search for interesting depositions. There's a couple of my favorites. When I practiced in Houston for 20 years, many of you may know the name of Joe Jamale, wealthiest lawyer to ever live thanks to the Pennzoil-Texaco settlement. But he and his son Dar, I worked with a lot. They officed right across the street from me, and they handled a lot of high-profile cases. You can look at Joe Jamale's depositions where experts took the bait when he tried to intimidate them or insult them indirectly, and they took things personally. And as a result, they tried to be condescending, as though they were speaking over the intellect of the attorney. And what you're going to be doing is speaking over the intellect of the jurors. So do not be condescending, just be confident. Teach without going on and on. There are some experts I've seen who love to listen to themselves. They're argumentative with opposing counsel. These are tricks that we use when deposing a defense expert. Don't let them use those tricks with your experts. Data, graphs, photos, animation, these things make learning interesting. And interesting learning, only an interested juror is going to learn. Let's put it that way. So hiring the right expert, definitely important. Well, let's talk about the wrong expert, things to avoid when hiring an expert. If the expert requires a large retainer that is far in excess of the amount that they will need to review the materials, it's generally one of two things. The first thing is it's one of those rare experts where supply and demand is really calling out to this guy, and he is the creme de la creme, and he can ask for that large retainer. But more often than not, this is somebody who, this should be a warning sign. It's a sign of what's to come. If you suspect an expert is charging far more than they deserve, you should be candid and express concern. An honest expert will be willing to charge a fair price for the work rendered. Number two, the expert is difficult to get a hold of or fails to promptly return calls. An expert is not only there to testify. I don't have time to talk to you right now. Just tell me when the trial is. Well, that's not going to work. They're also there to assist you as you work on a case. And in this way, specialists can play a fundamental role in the development of any strong case. I use my experts not only when I'm working with them and prepping them for depositions and working on their reports and working on their opinions. I want them to tutor me. I want them to take me on a journey from point A to point Z on what it is about this area of the law that I need to know. I had several cases involving catastrophic failures of large turbines, one in particular at the Kansas City Power and Light Facility in Kansas City. And I hired an expert. I won't use many names in this webinar, but I will use the name Marwan Boyce out of Houston. Just an incredibly fascinating, super smart guy. I mean, I felt like I'm 6'7". I felt like I was, 4'2" when I'm sitting on the plane next to him, and he's describing what it is he understands about jet engines, and he was the main expert for Continental Airlines back in the day. And it's important that you trust your experts. So they're there to tutor you. He walked me through the history of turbine engines, and I first learned that during the 70s, Indianapolis 500 race cars were actually jet engines until they just got too fast, and then they had to stop and ban those jet engines. I mean, I learned a lot in a 3-hour flight with this expert, and that's what these experts should do. The expert's appearance is not ideal. This one's a little touchy because of the way we deal with these issues in our society, but understand that you're selling a product. You're selling this expert, his opinion, and your case. If your case is likely to go to trial, his ability or her ability to testify in court is a key. A number of factors have to be considered with the jury's perception in mind. The ideal candidate, if too old, and I sadly, I just had a case, no names of course, but I just had a case in Hawaii where my expert in this case was going on for 7 years, a death case, and we had the workers' comp aspect of it, called me about 3 months before trial and said, I'm afraid I can't testify. Well, why? He had rapid onset of Alzheimer's and said, I can't even give a deposition anymore. So you need to think about these things, and where there's any problem with your expert dying or becoming infirm, you must get a deposition and preserve their testimony. So too young, I hate to say it, you know, what's that, there's a series on TV right now with the doctor, The Good Doctor or something like that, there's this kid, but he's just so brilliant that he comes up with all these unique cures and you know, things like that. That guy may be a genius, but the jury doesn't know that. They haven't seen The Good Doctor, so you put that guy on the stand, and he's not going to make a very good impression. Location is always an important role. Expert witnesses from far, far away from the locale of the trial may leave the jury wondering why you couldn't find somebody closer. And what do you think they're going to think? Well, nobody would buy your side of the case until you had to go all the way to Alaska to find an expert. Next, the expert has very little or no testifying experience. I can't overemphasize how important testimony is. That's why when I talk about our database of experts, I am always looking and keeping in mind how good this expert testifies. There's an expert that we've used for a number of years who seemed to have a very fatal flaw. Very, very good, comes in, great reports, great opinions, and then in deposition or a trial when asked, are you 100% certain that this is what happened? Well, no. Could something else have happened? Yes. And these are not fatal answers, but ultimately not standing up to your opinions as an expert is going to be fatal. So the candidate does not have to have the same specialty or subspecialty as the defending expert, and be on the lookout for any professional disciplinary or ethical complaints or actions against the expert. Nowadays, it's common to look if that expert has ever been disqualified under Daubert, and so you're going to want to know that. When do you need an expert? Okay, this is an ultimate question for subrogation professionals because of what we do. It's evident that you know what the basic purpose of an expert is, but when to use an expert is a question that is one for the ages. Experts can provide special knowledge, or they can provide damage assistance. The first case I ever tried, which was in Rosenberg, Texas, at a rural country bumpkin courthouse, and the defense counsel was playing dominoes with the judge when I walked in. And I was probably 26 at the time. I put on a great case. It was a house fire. The house burnt down. It was a complete loss. I put on my electrical engineer. I put on my damages expert who came in and testified that, yes, this is what we paid X dollars, and it was a mid six-figure case. It was a nice house. And then when it came to close, they moved for a directed verdict and said, well, all they put on was evidence of the replacement value. And my expert had come in and talked about replacement value. Well, of course, you can't recover replacement value in a courtroom. You have to recover the actual cash value difference in market value before and after. And that's a whole subject in and of itself. And we have charts on that, by the way. But I actually got to the jury, but the jury found liability, but couldn't conclude the damages. And we appealed it and ultimately lost because I didn't have the right damage expert in that case. And I learned a lesson that I've never repeated since. So In deciding whether a claim that you're handling requires an expert, you must ask what you're going to be required to prove. This is why you always have to think like a lawyer. Don't hesitate to contact us and ask for our advice on those questions. But auto collision, intersection collision, expert may not be required. You want photos, surveillance video, witness testimony. The duty is clear here. You don't need an expert. Auto collision, where there's a dangerous condition of the road surface. Well, now you're going to need an expert. Auto collision involving the crashworthiness of a vehicle. Expert needed. Tire defect, tire blows out. You cannot just say, well, the defendant was driving down the road and the tire blew out and he swerved and hit our car. Therefore, he's at fault. Well, why was he at fault? No, you and I can't help it if our tire blows out, as long as we, unless we can prove some poor maintenance or abuse of the tire. We often have to go to the tire manufacturer and prove that there was a tire defect. Where there's a dispute over repair costs, you sometimes need a repair expert to come in and testify. If there's a flood loss, you need a hydrology or a hydraulics expert to discuss and illustrate the behavior of water and cause and why the negligence of the defendant allowed the water to damage the insured's property. Slip and fall on ice and snow. We see far, far too many of these cases, and we will not stop seeing them. But you may not need an expert if you have investigation that clearly shows the dangerous condition, perhaps a contractual duty to salt. In those instances, you don't need an expert if you have the right investigation. So guess what? You know those other webinars that we give where we talk about doing the investigation thoroughly up front and the importance of it? It can cost you. You want to subrogate a claim, your insurant or your client wants to subrogate a claim and you haven't gotten the right investigation, now an expert may be needed, and that increases the cost of the case that could have been avoided. So these are just some examples, slip and falls on stairs, things of that nature. But when do you need an expert? Whenever the jury has to hear things outside of their knowledge. The cost-benefit analysis, great question that's asked is, okay, who pays for experts? It's going to cost you $1,500 to have an expert come in, do some inspection, and then write a little report. Again, we're going to talk about when to have that report written in a second, but the party who hires the expert usually pays for the initial expert work. Those fees are charged to us as a subrogated carrier. It's an expensive litigation. We get budgets. We try to keep in mind the fact that we have to be cost effective. Federal Rule 26 and many state rules across the country require that a party who wants to take our expert's deposition has to pay the expert a reasonable fee. I will tell you that this rule has kind of fallen into disuse because it can just be used on both sides, and it often ends up being a wash. Whether preparation and travel time for an expert can be paid for depends on the jurisdiction. 7th Circuit up here by us, no, they don't allow it. 2nd Circuit does. States vary, but again, there's some angst over requiring a deposing party to pay for the preparation time for the obvious reason that both sides benefit from that preparation. California has a rule that says that a party desiring to depose an expert witness has to pay the reasonable and customary fee. This is, anytime you have to explain what happened and why, you need an expert, and you should go into the cost-benefit analysis. It's not always easy, and you can't be 100% accurate. That's where you can use us to help. So is your expert really an expert? We talked early on, and I'll just briefly go over this, the Fry case, the Daubert case, and the Kumho Tire case. The courts are the gatekeepers. We know this from previous seminars we've been to, conferences. So I won't go into it. Rule 702 of the federal rules discusses testimony and what's necessary, but Daubert applies to all expert testimony, thanks to Kumho Tire. And just understand that if you don't hire the right expert, you may end up with no expert at all. And that's there's a lot more that can be talked about. This slide can be the subject of a seminar unto itself. If you're doing a lot of litigation, again, I'm going to refer you to our chart on when experts can be disqualified and what's necessary. How do you hire an expert? How do you hire your expert? Where do you find them? Well, you can get them from expert referral services. Literally, you can go to Google right now and hire metallurgist experts, Utah. And you're going to come up with 5 or 6 ads that pop up on Google. These are national firms that have paid to be at the top of the list. I generally ignore those to begin with, and I go down until I find some local people. I click on them. If their CV isn't available, I move on to the next one. Google is our friend when when looking for experts, but again, you won't get all the information you need. You can use an expert referral service. Reasons to use them: because they have experts who are prepared. You have CVs, you get your hourly fee rate, and you know exactly what to expect. Reasons not to use them: they tend to be a lot more expensive. And these expert referral services start up like, they're like weeds almost. I mean, you can find them all over. Finding a good expert referral service is almost as hard as finding a good expert. So what do? To seed their stock of experts is they go out and grab anybody to start with. So you want to research not only the expert, but the expert referral service as well. There's good reasons to use them, and they can be a friend if used discriminatingly, so be careful. Internet searches, referrals, that's the best. I literally, and I say this not because it's us, if you need an expert, Aaron Plowman is one of our litigating attorneys. He's a senior litigator with us, Aaron Plowman. Aaron is not only a good litigator and handles a lot of product liability cases, but he's an engineer, and he speaks their language. I'm always going to him and saying, what does this mean? What does that mean? Aaron is also in charge of our expert database. So if you need somebody, you can contact myself, you can contact Aaron, and we'll be happy to help you. 10 questions. There's listservs here. I don't like listservs, and here's why. If you ask somebody at a party, who's the best lawyer in town, you will actually get answers from people who have no idea who the best lawyer in town is. Why? Because human nature is such that when we are asked for our opinion, we value that request and we want to answer it, because to say, I don't know, in our mind leaves the questioner down. It disappoints them because, oh, I thought Gary knew who the best lawyer in town was, and now he's telling me he doesn't know. I guess he doesn't know much at all. It's human nature. So when you ask for a referral on a listserv, you're going to get some claims adjuster from Birmingham who's going to say, oh, I've used Bill Schmidt. I use him on all my fire cases. Okay, who else have you used? Well, nobody, just Bill Schmidt. He's the best. Well, that's not much of a universe to go from. Bill Schmidt may be good for you, but how do you know he's the best? So listservs are questionable. Personal networks, they work well. One of the bad ways to find an expert, and I know you guys, your hands are tied sometimes, when your company says, here, we have a contract with this guy, use him. Guess what? This is one of my 10 subrogation mistakes that insurance companies keep making in that webinar, where you go out and hire somebody to handle all of your fire investigation because they supposedly give you a cheap rate. You get what you pay for, and this isn't a one-size-fit-all issue. So 10 questions to ask before you hire an expert. Ask the expert, has he served as an expert only for one side or the other, plaintiffs or defense? You don't want somebody who's biased or who can be held out as a hired gun or a gunslinger. Ask, has the expert ever been disqualified from serving as an expert witness? If they lie to you, you can get your fees back later on if you find out they have been. Has the expert ever been terminated by hiring counsel or withdrawn from any previous cases? A yes answer to this isn't necessarily bad. You just want to find out why. Actually, the integrity of an expert who withdraws from a case, that might actually improve his credibility instead of hurting it. But you just want to ask the question, has the expert ever been terminated or asked to resign from a job? Has the expert ever had a client terminate a contract for services? Has the expert ever been arrested? I mean, why would you ask that, Gary? Well, because the defense will ask it. And then it's out there. Yes, I was arrested for civil assault. Well, now all of a sudden the jury isn't looking at that slide with the colored house. Remember early on? They're not focusing on what it is that Svengali is trying to get them to focus on. They're now focused on, oh my God, civil assault. What could that be? Was it against his wife? Was it domestic battery? Now their minds are all over the place. You've failed to focus them, and that's the job of your expert. Does the expert have adequate credentials and experience? Get his CV. Obtain a list of previously handled cases. That's important. It can give you a lot of information. You can go to the attorneys who hired them in that case and find out how they did. Fire cause and origin experts. I'm going to just go over this quickly. This is a common mistake. I maintain, there are some exceptions, but I'll maintain that there is no such thing as a cause and origin expert. An origin expert is somebody who is they're generally an expert that's been trained in fire science or fire chemistry, explosion dynamics, computer fire modeling, fire expertise. They're very good at what they did. Previous firefighters who went on for advanced education, they don't necessarily have a bachelor's degree in mechanical engineering or a PhD, but they're good at what they do in finding out why a specific product, where a specific fire actually began. What caused the fire is a different question, and fire investigators have flooded the insurance market, but far too few of them are properly qualified to even provide a sound origin opinion, and yet alone a cause opinion. So it's important to find a good origin expert, but remember that's what they're there for, origin, not cause and origin. They're there to tell you where the fire started. Now you know where the fire started, and assuming you have enough time before something's repaired or evidence is removed, now you bring in your cause expert. You believe it might be electrical. You know it started under the hood of the car. You get an auto mechanic, an auto expert who comes in, and now he says, yes, the cause was that the hose was rubbing up against the fan belt, and that caused the hydraulic fluid to leak onto the manifold, which caused the fire, which lit the combustibles nearby. Now you have an actual expert with regard to the cause of a loss. And NFPA 21 for dummies. This is becoming big stuff. The National Fire Protection Association is a U.S. trade association that creates and maintains standards, and they've written something called the Guide for Fire and Explosion Investigations. NFPA 921 is universally accepted today, and it's printed in multiple languages, and old fire investigators used to support the old negative corpus. I'm going to rule out this, this, and this, therefore what's left started the fire. Well, that's not consistent with the scientific method, and 921 refers to it as inappropriate and not to be used because it generates what 921 calls an untestable hypothesis. To be safe, make sure that your expert uses and does their investigation in accordance with NFPA 921, and you'll be in good stead. It's only a guide, but it's fast becoming the standard by which all fire investigations occur. There's a couple things I would have time to mention, but we've only got another 30 minutes left, and I have a bunch of stuff to get through. West Fertilizer Explosion Company, I was going to give a war story about the old West Fertilizer in West Texas explosion, the ammonium nitrate explosion down there. There's a picture of it in the center that you'll see. This is a case that we've been handling now ever since the explosion. We are getting close to resolving the case. We're set for trial this next spring, but it is, as you might imagine, a case that's just replete with experts and rebuttal experts and rebuttal experts. And the key was going through millions of pages of documents and coming up with a few smoking guns. But that case wouldn't be viable were it not for the experts. Scene inspections, examining evidence. Again, follow NFPA 921. We have a tendency to want to send defective products to the manufacturer and let them look at it because we're thinking, well, surely if we do that, they'll pay us. And we can count on one hand the number of times that's been successful, unless you just completely sell out on a property subrogation claim. It's always a good idea to tell your expert not to reduce his or her opinion to written form until you've had a chance to discuss it A report written in 2015 is going to look awful deficient and awful suspicious in 2018 after more facts have been discovered. I love cross-examining experts that have written reports years ago, because what I'll say is, well, did you know when you wrote this report that X, Y, Z? Well, no, they didn't, because that evidence hadn't come out yet. Wouldn't it have been nice for you to know that when you wrote your report? They can't answer that question, no. If they do, it's a whole other rabbit trail they get taken down. So don't pay somebody to document that you have no chance of recovering your subrogation dollars. Write it in your claim notes. Don't ask for a report. First of all, you pay for the report. Secondly, if you ever come back, or if the case gets bigger, or you have someone take another look at it, you're going to be in a world of hurt. A large national quote-unquote subrogation firm was handling a big fire loss, started with a Maserati, a rare Maserati, by the way, that started a house on fire and burned down an entire complex. And they ended up saying, no, there's really nothing here. We can't go forward. Well, we took the case on after they dumped it and ended up getting a very, very nice recovery down in Texas. What is interesting is our experts, we required Maserati to provide all of these schematics, the electrical schematics. They were a foot thick. Page after page after page were printed out. Well, what our expert discovered was they weren't meant to be viewed on paper. They were electronic. The Italian designers put all of their schematics on an electronic form that you clicked from one to the next, showed how all the wires were connected. It was just gibberish on paper. And we were able to get the judge to sanction them. And we had a very, very good auto expert in that case, who is listening, by the way. And sorry, I'm not giving any endorsements because that's not why we're here. But anyway, so if you're doing any destructive testing, make sure you put everyone on notice. Not having someone on notice can lead to spoliation issues. Experts report. This report should answer the client's questions. The expert must understand what questions the client needs answered. What happened? Why did it happen? How could it have been stopped or prevented? Whose fault was it? Was it a product design defect, a manufacturing defect, a marketing defect? Under the new 402A or B restatement, is there a reasonable alternative design? So our experts, especially in product cases, have to not only tell us there was a defect, they now have to tell us there is a reasonable alternative design. You know what that means? That means that now you have to have experts with design experience. A good mechanical engineer who says, yeah, I think this failed because of a short and arcing, and well, what design would have been a reasonable alternative design would there have been? And if they can't answer that, then your job is not done. Documenting the expert's work. The report should describe what they did to lay the foundation for opinions, describe the investigation, the research, etc. It should be clear. I always say avoid feckless dithering. Don't go on and on and on about the history of the automobile in your report. Don't use technical jargon or acronyms without clearly indicating what they are. Remember, the guy who sacks your groceries is the guy that you're going to convince to pay you $2 million in a case. That's not easy. His preference is probably not to do it because he doesn't have $2 million. Why should he give you $2 million? You have to prove to him that you have been damaged. I mentioned earlier, it was the Albert Einstein quote that goes, if you can't explain it to a 6-year-old, you don't understand it yourself. Be clear. Use solid scientific evidence, clear conclusions and opinions, and if the insurance tendency is to write a report to justify the cost, bad move. Do not write a report until you have to. Wait till the bitter end, because there is always something more and better that can be put into that report, or something bad that will have to be explained away in that report. More facts will come in. And it's hard to explain new facts if they're not considered in a report. So that's important to consider. Discovery and draft reports, I'll just cover this real briefly. This is more of a lawyer thing, but it's good for all of us to know that in 2010, the Federal Rules of Civil Procedure underwent a major revision, and Rule 26 no longer allows the full discovery of draft expert reports. reports or broad disclosure of communications between attorneys and expert witnesses, as had been the case since, well, as long as I can remember. Instead, draft reports and communications are now protected by work product doctrine. And again, we're talking federal, and state law is going to apply too. Just know that this gives us a little bit more of an ability to work with our experts. You get a draft report and you go, wait a second, that's not what I asked. Well, it would be horrible if you had to go back and fix that draft report, and it would be discoverable later on. It makes it look like nobody knows what's going on. I mentioned Aaron Plowman earlier. He does a lot of our product liability cases. He wrote an article called Keeping Subrogation Out of the Dumpster about spoliation. Uses the example of a July 6, 2013 fire which occurred at the Milwaukee County Courthouse. Some pieces of electrical equipment started on fire, closed the courthouse for an extended period of time. We're the most populated county in Wisconsin, so the disruption came at a significant price. There was $13.5 million in damages. And lo and behold, despite having noticed, the Milwaukee County officials disclosed that a county employee had discarded and scrapped key pieces of electrical equipment. And that was an expensive mistake. So investigators must ensure that the artifact is collected, safeguarded, and preserved. If you're using an investigator or an internal SIU guy, make sure he understands that our job is to maintain the chain of custody. We have to prove that that product is the one that was in that courthouse at the time of the fire, and we have to preserve it in a pristine condition. If it's stored outside, subject to rain and snow and sleet and sun, you better believe that that's going to be mentioned by the defendants. Just real quick, a quick story. When doing the investigation, I always tell people that we have the burden of proof. We have to prove the defendant was negligent. We have to prove that this negligence caused the damages for which the carrier paid its claim. And we have to prove the amount and the nature of those damages. If we fail with regard to any one of those three elements, simple inaction will have snatched defeat from the jaws of certain victory. And so it's important to be thorough. This is where I talk about the investment of subrogation. Don't get chintzy when it comes to the investigation. Pick up things, preserve things that you think may have no relevance to the case. You can always discard them later. In a very high-profile case that I had down in Texas involving a defective Mack truck, we actually bought the Mack tractor, we bought the trailer, we stored them in a warehouse for 5 years, but it was worth every penny. In the end, it was a confidential settlement, but the result of it was that we took the time to pick up the evidence. A parable that I often tell, and maybe you've heard it, goes something like this. There was a group of traveling nomads preparing to make camp for the evening in the desert, when suddenly they were surrounded by a great light from the heavens above. They knew instantly that they were in the presence of a celestial being. A loud voice spoke from the heavens. Gather as many pebbles as you can. Put them in your saddlebags. Travel a day's journey, and tomorrow night you will be both glad and sad. And then, as quickly as it appeared, the voice and the light disappeared. And the nomads looked at one another in disbelief. They had expected, with this voice from above, some revelation of a great universal truth, the key to wealth or happiness. But instead, they were told to pick up some pebbles. It made no sense. It was a menial task. So dejected, each one did pick up a few pebbles, and they put them in their saddlebags. And the following morning, they broke camp and traveled a day's journey. That evening, when they made camp again, they reached into their saddlebags and, to their great surprise, discovered that the few pebbles they had picked up had turned into beautiful and flawless diamonds. Instantly, they were both glad and sad. Glad that they had bothered to pick up a few pebbles, but sad that they had not stuffed their saddlebags full when they had the opportunity. In investigating a claim, your expert, your investigator, you must realize you don't know which pebbles are going to turn into that flawless diamond. The cases can take too many twists and turns. So just follow the premise of that parable. And when a cause of loss seems apparent, Don't stop with simply securing the evidence needed to prove your case. Your expert will be asked about, well, did the microwave next to the defective can opener, did that have any cause? No, I don't believe it did. Well, how do you know? Did you look at it? Well, no, it was discarded by the time I was hired. You've now handicapped your expert. You've tied one hand behind his or her back. So take the effort to disprove and eliminate alternate theories, because I can guarantee you the other side will claim any and all possible alternate theories as the cause of the accident. Okay, it's time for our trivia question. And because we're dealing with experts, I thought a science question would be awesome. And here it is. An earthquake that measures 8 on the Richter scale would be how many times stronger than an earthquake that measures 4 on the same scale? An earthquake that measures 8 on the Richter scale is how many times stronger than an earthquake that measures 4 on the Richter scale? Go ahead and send in your question, and we'll announce the winner in just a little bit. So, tips for making the best use of your experts. I'd like to write a book called Training Your Expert to Obey Simple Commands. I don't mean to be demeaning to the experts in the audience, including the ones that I use with some frequency. It's just, I've found this to be an indispensable tool, and claims adjusters, subrogation professionals, do this with every expert. You must know what it is your expert is supposed to say. From the very moment you hire him, you want to know the words that must come out of his or her mouth to win the case for you. I write down the exact testimony that is needed and I expect, and when I'm prepping that expert, I have him say the words back to me. And then to emphasize how important it is, I have him or her say it back to me again. I just can't overemphasize how important it is to train your expert to obey that simple command. If they cannot say those words to you, you do not want that expert. I'm not suggesting that they should say it if it isn't true, but you just want to make sure they understand the medium through which they have to communicate to the jury that's going to win the case for you, because the jury is going to be asked that exact question. I remember the expert saying that. So, okay, assume every communication is discoverable. That's not technically true, but assume it is. Anything that goes back and forth with your expert, do not send them emails when a phone call will do. Do not send them a letter saying, you know, what about this? What about that? Because everything that goes back and forth will reflect uncertainty on the part of your expert, especially early on in the investigation, and will reflect perhaps that you're trying to get them to say something that they otherwise wouldn't say, and all of that can be used against you. Prepare the expert. This is so important. I take at least a couple of hours before a deposition. We go through every scrap of paper, and I train the expert to obey simple commands. I need you to say these words. These words have to come out of your mouth. You know, and there's a few mistakes that experts make, and for those experts in the audience, I actually am a forensic expert in that I am hired a lot to give opinions on subrogation issues and cases across the country. I have a CV with a list of cases that I've testified live, in trial, in deposition, and so I understand, and I've been challenged a number of times under Daubert and have never been disqualified. But here's, so I understand your pain, but a few things. Don't rely only on information provided by the attorney. You know, you got to go out and have a full knowledge of all the underlying facts. You need full access to all the relevant records. I used to be years ago when the expert would ask me for all this stuff, and I'd say, well, you don't need that. That's just so you're going to bill me a whole lot more. Until in one case, the expert was asked whether he reviewed a certain category of documents, and he said no, and then looked at me like, dummy, had you just given me those, I could have said yes. So that's important. Don't forget, number two is a mistake, is don't forget that you're an advocate only for your own opinions, only for your methodology. You're not an advocate for the case itself. The case will be won by the lawyer, and by the fact witnesses and by the plaintiff or by the defendant. You're there to advocate, defend, and circle the wagons around your opinions. That's all you need to do. If you do that, the chances of winning are great. If you advocate for the case, the jury will quickly detect any specialized agenda the expert may have. I'm board certified in personal injury law, civil trial law by the Texas Board of Legal Specialization, the National Board of Trial Advocates for civil trial law and appellate law. And I've tried my share of cases, and I've been able to get experts to switch sides during examination. So I have an insight. I'm not an expert on being an expert, but I have an insight, and I know that a jury will quickly detect any specialized agenda that an expert may have. And the expert's credibility, in my opinion, is directly proportional to the extent of the jury's belief in his or her objectivity. Don't put too much on writing experts too soon and too casually. There's no need for it. You can make notes. Make them so you know what they mean, but don't write a report before you're asked to write a report. Don't sound too much like an expert. You want to be sincere. You don't want to talk down to the jury. Remember, Will Rogers once said, "Everyone is ignorant, only on different subjects." Well, that could be said another way. Everyone is an expert, only on different subjects. Don't be condescending. Give complete answers. And learn to say, "I don't know." Saying "I don't know" builds credibility. It doesn't make you look dumb. If you're asked, were you asked to testify? If you're asked on the stand or in deposition, what were you asked to testify to in this case? Never respond affirmatively. We're not asked to testify about specific things ahead of time by attorneys. That's what you should say. You're engaged to make a careful study of the facts, provide an expert opinion about the subjects that you've been asked to investigate. That's it. What are your opinions in this case? That's a tough question. It's a valid question, but one which carries some potential harm. This is because you may forget to include something, and opposing counsel could then use your answer to preclude you from testifying about other things. So just confer with your attorneys. I always ask if you want to know everything, I will make a list. Oh, I did this, and 90 minutes into making a comprehensive list of opinions, we just moved on in the deposition and he skipped the question. Can I see your file? Yes, the opposing attorney is allowed to see your file. Refer, with the attorney. Can an attorney force you to answer a question without referring to your files? No. I want to know what you know just sitting there, not what you can read to me. Maybe something a lawyer may say. I will conclude the deposition immediately. Don't let yourself be caught reciting technical definitions without reference. Any other opinions you're going to give at trial? These are the classic closing questions. Always answer that you may provide opinions about any number of subjects as directed by your counsel as the facts arise. And then lastly, don't get flustered. Don't take personal attacks personally. Watch those Joe Jamail YouTube videos if you think that's going to help you. It will not. Prepare for an attack on your resume. I'll just go through this real quickly. Experts puff and make dubious claims. Sometimes they're selling themselves. Be careful. Don't put too much in your curriculum vitae that's not correct. Obviously, not any credentials, degrees, accomplishments, certificates that you don't have. The other side, if they're doing their homework, they will discover those things. Blinding an expert, I'll just tell you about real quickly. If you have a significant case, this can be a powerful tool. Like all human beings, experts are susceptible to being influenced by outside information. When you call an expert and you can say two things. You can say, I have a case involving a truck which the tire blew and it went into the ditch and killed a bunch of people. Can you help me prove that the tire was defective? Well, now you've got a little bit of bias built in. And if the expert answers the question truthfully, it's going to make you look like you're wanting this expert to say something before he even knows anything about the facts. A trial strategy known as blinding an expert gives a solution to this where you can withhold certain pieces of information. Go to an expert without letting them know which side you're on. Give them the facts of the case and then ask them to provide you with a preliminary opinion, nothing in writing, and you're giving them a set of screened materials to review. And if their findings aren't favorable, you can end the relationship and move on. But later on, he will be or she will be able to testify they were blinded when they were engaged. That is cool, because then you can ask the other expert, were they blinded? Well, no. Well, which do you think looks more has more credibility with the jury? So that's a good. Blinding an expert is a great tool. Locking out and disqualifying experts. I have to admit, this is something I've done in the past, especially when you have experts in a small number of experts in a particular discipline. Let's say e-cigarettes or tires is a great example. I had a tire case where I actually went to and attended a 2-week Band-Aid tire vulcanization class, how to make retread tires. I just put on a smock like everyone else and learned how to make the tires. And then when I came back, I went out and hired, and preliminarily hired, gave information to all of the best experts, chose the best one, and then, of course, the others were locked out or disqualified. There's a couple of cases. It's actually unethical to do that. Rule 3.4 of model ethics rules says a lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do such act. So arguably it falls within that. The Flagpole Strategy, you can tear down an expert on cross-examination, but another powerful strategy is to turn the expert into your own witness to advance favorable facts. The effect of having a hostile witness agree with talking points of yours in front of a jury is profound. So consider a standard car accident case in which the plaintiff seeks lost wages. The opposing expert may opine that the plaintiff suffered a debilitating back injury, but you can go through and ask him basic facts, preliminary facts that help your case that he has to agree with. And every time you do that, some juror, whether they're allowed to take notes, might make a note or make at least a mental note. And then work ahead with your experts to make sure that that flagpole strategy isn't used against them. Jamie has not given me the trivia winner yet. When she does it, I will announce it. But let's talk about something that's called the Reptile Brain Strategy case, which the Reptile Brain Strategy, which is, there was a book by Don Keenan and David Ball back in 2009 called the 2009 Manual of the Plaintiff's Revolution, Reptile. And they advocate persuading jurors by appealing to their reptile brains, the oldest part of the human brain that's has its roots in evolutionary theory. It's responsible for primitive survival instincts. The human brain consists of 3 levels of functioning: reptilian complex. This is the brainstem, cerebellum, hypothalamus. We share this with all animals and reptiles, and it governs our most basic like functions, primitive survival instincts. Then we get to the paleomammalian complex and the neomammalian complex. But the reptile strategy is you appeal to the established danger to the community. You're talking about a tire case on a truck. Well, you can now ask questions about how trucks can easily destroy a small vehicle and kill the family inside if the tire explodes and they swerve. You can convince the jury that they have the power to improve their community's safety. They take that responsibility quite seriously. So now your case, holding for you, finding for you in that case, takes on new and important social meaning. You've appealed to their reptile brain. And I know it sounds bizarre. I'm getting it from the name of the book, but questions are posed in such a way as to make the witness appear foolish if he or she doesn't agree with the premise. Does the defendant agree with the statement that the car manufacturers must make their vehicles so they operate in a way that they represent they will operate? Well, yes, you have to say yes to that. Doesn't help your case, but you have to say yes. Does the defendant agree that if a car manufacturer makes a vehicle that has a defect in materials or workmanship and someone is injured because of that defect, then the car manufacturer is responsible for the harms and loss caused? Yeah, that's the law. They have to agree with that. Do they agree that there's a huge danger to the public when a truck is driving down the road with a defective tire? Yes, they have to agree with that. They're not saying that their truck of their client had a defective tire. They're just saying that it's a danger. But the implication to the jury is that that is the case. Jamie, do you have the trivia winner yet? Okay, she says she'll have it in a minute. So this is an important and powerful technique to use with the experts. And again, this is getting a little nuanced into the actual use of experts, but by and large, remember the parable of the pebbles. You and your expert and your investigator need to pack your saddlebags with as many pebbles as you can, because you don't know which ones are going to be diamonds, and you don't know which ones the experts are going to use. The worst thing to have happen is you have your investigator go out, they get parts, then of course you make the mistake of sending the part to the manufacturer, and after 18 months of back and forth, they of course tell you the inevitable, no, we're not going to pay it. That can hurt when you finally hire an expert and you litigate because no one's paying you, and your expert says, well, I need to know X, Y, and Z. Well, we didn't preserve that. We didn't get that information. We didn't save the power cord run all the way to the receptacle. We didn't save the junction box, or whatever it is, whatever pebble it is that would have turned to a flawless diamond is still laying out there in the desert. You didn't put it in your saddlebag. So these are important. All right, trivia question. Hey, I actually know you, Diana Winslow with Gallagher Bassett. Awesome. You are the winner of the trivia contest, the trivia question. And of course, the question was, an earthquake that measures 8 on the Richter scale would be how many times stronger than an earthquake that measures 4 on the same scale? It's not twice, it's not 4 times, it's 10,000 times stronger. The Richter scale is logarithmic, which means that each successive whole number represents a 10-fold increase in power. Thus, an earthquake that measures 8 would be 10,000 times stronger than an earthquake that measures 4. By the way, only 8 people got it right out of nearly 500. I wouldn't have gotten it right, but of course I looked it up. So congratulations, Diana. You've won an all-expense-paid trip to, oh no, wait, it's a book. You won one of our subrogation books, which is even better. You know, think subrogation. Subrogation implicitly requires being cost-effective. You cannot subrogate in a growing number of cases. Think of Gandalf in today's civil litigation arena without an expert. Knowing when to use the expert is hugely important. If you can get by without one, great. If you try to get by without one when you couldn't get by without one, it will cost you everything. You get what you pay for. Thrifty and parsimonious decisions when it comes to subrogation and getting an expert. They have a way of ensuring that you're simply throwing good money after bad. You don't want to hire an investigator if you're not going to hire a cause expert to follow up. And if you send me the file and you've got the origin expert and he's saying, yes, it started over there by the furnace, but hasn't pinpointed a cause, or worse, has pinpointed a cause even though he's not qualified to pinpoint a cause, only the origin, that's even worse. So an expensive expert should not be used on small subrogation files. That defeats the whole purpose of subrogation. Some smaller claims may require an origin expert to also serve as a cause expert, notwithstanding what I just said. Sometimes it's all you can afford in a case. Don't be chintzy in a case that involves a good deal of money thinking you can get by with it, because generally you can't. In a smaller case, it may be enough to push the other side over and have them offer you something. But you know, we've spent the last 35 years building this electronic and searchable database of experts across every possible discipline. Use it. Talk to Aaron Plowman. talk to us. The wrong expert can destroy a good subrogation file, while the right expert can breathe evidence into it. With that, I see we have some questions. Before I get to those questions, I mentioned the resource charts that we have on our website. There's probably 50 of them that cover the law in all 50 states, including the one we referenced in here about experts. We have a subrogation laws by state map where you can click on any state and all the subrogation laws will come up. You can refer any file to us through a referral file feature with 2 easy steps. You can securely upload your file, and then you get a date timestamped receipt, and then we'll look at it and get back to you with a plan of action or see how you'd like us to proceed. There's an ask a question feature. When you have a question, it could be a question on an expert, it could be a question on the made whole doctrine, or it could be a question about loss transfer in New York. Whatever it is, you can fill out that, and we normally get an answer back to you from any jurisdiction within an hour. We can do that because we have over 300 contracted local counsel. We have offices in Louisiana, Los Angeles, here in Wisconsin, and as of January 1, we are going to have a new office in Austin, Texas. And Texas is where I practiced for 20 years, so it's almost like going home. I'm proud to announce my son, Lee Wickert, will be heading up that office along with Jim Busenletter and myself. We'll be back and forth. So now to the questions. I've got to pull this up. And, I see we have quite a bit. I'm going to answer a few of these, and the rest I will answer by email. What if an expert changes their mind? And this is Robert in Tulsa. There's many reasons why an expert would change their mind. Advances in science, advance in their understanding of the evidence, new evidence, additional experience, errors. It can happen. If an expert changes their mind and does a complete about face on you, you no longer have a good expert, and you might talk to them about getting a refund. But you do have a duty if the expert changes their mind to reveal that under Rule 26 of the federal rules. That's problematical. If an expert dies, can I still use his report? This is Connie and Griselda in Baton Rouge. Welcome. By the way, our New Orleans office is right down the road from you. If an expert dies, can I still use his report? No. You can use it to try and settle the case. You don't necessarily have to tell the other side your expert died, but a report is considered hearsay. You may be able to get parts of it into evidence if you have a second expert who's relied on that report. But for the most part, it's like a auto accident police report. You may be able to use a deposition of the expert if one was taken. That's why I always use video depositions of experts if they make a good appearance. Remember, we talked about that. So no, you can't use the report as a substitute for live testimony. Our Constitution does not allow that. Gerald in Stockton, California. I am a forensic expert in California. The subrogation, I think that was supposed to be subrogation attorney who hired me, refused to meet with me before I was supposed to testify. Is that normal? No, that is not normal. I'm not sure why they would waste money on an expert if they're not going to take the time to prepare him and meet with him. Meeting with the attorney, especially the attorney who's calling you to testify, is essential to your job as an expert witness. Only the attorney can explain his or her overview of the case to you and what they see as the value of your testimony. You may differ with that, and I've had experts re-educate me on a particular case. You're looking at this the wrong way. It's not the defect; it's the guard that wasn't provided, or something else, some other aspect of the case that I should look at. By the way, experts, one mistaken statement can be very, very expensive. One of the largest subrogation recoveries we've ever had. It was a spastic quadriplegic work comp subrogation case in which we represented the injured employee also. This was down in Texas. Very first deposition was of an expert who did not meet with his attorney, and later and told me so in the deposition. And so I asked his theory of the case, and it was a defective truck tire case, and he said ozone cracking. You know, if you see these RVs that are out there in the sun, they always cover the wheels. That's to prevent the vulcanized rubber from cracking due to sun and ozone penetration. It doesn't necessarily affect the integrity of the tire, but there were cracks in this tire, and so that's what he blamed it on. Well, they left the tire outside exposed too long, and it had ozone cracking. Definitely the wrong thing to say. It haunted them for the rest of the case, and this was an 8-figure settlement, confidential, with General Motors and several Chemline Company and several other companies down in Texas. A good attorney will always find time to talk to their witnesses. One more question here, and then the rest of you guys I'm going to answer via email. Rebecca in Minneapolis. Hey, you got the same weather as we do. One of our experts keeps saying, I don't know on the witness stand, or kept saying, I don't know on the witness stand in a large property subrogation case we hired him in. Should I hire him again? Rebecca, it goes without saying that an expert will understand the scientific basis of the testing that was done. However, even the most educated and experienced people have gaps in knowledge and experience. In most cases, what you don't know will have no effect on the outcome of the trial. Eliciting I don't know answers is part of the job of defense counsel. They look for those things. If you start trying to answer as though you know and you don't know, that's worse than saying I don't know. Ideally, your expert would never say I don't know and would know everything. But again, that has the problem of somehow making the jury look at him and go, well, this guy's a know-it-all. I had an interesting case involving this was the Mack truck case where I hired an expert. It had to do with the tires in that case too. And I hired an expert from NASA down in Houston. And he was on the stand, and the question to him was, well, now, Dr. So-and-so, you're telling me that it would take a rocket scientist to figure out the revolution of the tire versus the radius versus the integrity of the vulcanization, taking into consider sky mark. And he just wrapped all this into one big question. It would take a rocket scientist to calculate that, wouldn't it, sir? You know, very condescending. And my expert just looked at him and said, well, sir, I am a rocket scientist. And I put that one on my desk. So yeah, there's nothing wrong with saying I don't know. I think sometimes it actually helps credibility. Don't speculate. Speculation is a word that doesn't belong in any expert's vocabulary. It's not admissible. Never say I imagine. Never try to reason out the best answer. Once you say you don't know the answer to a question, the attorney can repeat the question only so many times before the court will stop them from asking it. So yeah, I would hire him or her again and actually chalk up the I don't know answer to being extremely credible. Well, I want to thank you all. This has been an amazing crowd, and I appreciate the opportunity to present this information. If you have any questions, our contact information is on there, and we will, all of us here will be answering your questions via email. So thank you and enjoy the rest of your day. God bless.